On the slopes of Diamond Head. This is Kapiolani Community College. Kulia Ikanu'u, strive for the highest.
Aloha and welcome to Business Law 200. I'm Ben Carroll. Last session we just took an overview of what the course is going to look like, gave you an introduction, a little bit of a preview as to what we were going to cover. But let's take a look and see exactly how we're going to handle each class on these videos. So if you look on the slide, it indicates that we'll start out with review questions from the prior week. So there'll be 3 or 4 questions of dealing with material that we covered in the prior session. We're not really going to do that formally this time because we just, as I said, we did a kind of a sweep through the class, talked about some of the mechanics and that sort of thing, and that's all available on the website. So we won't have a formal review this time. Then we'll look at the agenda for the session. So we'll talk about what we're going to cover, give you an idea of what the material looks like. And then we'll actually talk about the new subject matter. So we'll get into the nitty-gritty. And then finally, we'll just briefly note what you need to be looking at for the next time. Okay, so looking at what we're going to cover on today's agenda, we're going to talk about the source of law, where it comes from. And again, we did kind of a broad brush last time, talked about the various sources of the law, and we'll get into that a little deeper this time. We'll talk about the government structure, so this will take you back to civics class. We'll talk about the 3 branches of government and how that affects how the law is made, interpreted, and enforced. And we'll look at some uniquely American features. So we did talk about how we have a common law tradition similar to Britain and some of the former British possessions, and how that differs from the rest of the world, which is largely the civil law tradition. But there's some unique American features that differ from Britain and other Commonwealth and common law countries. So we'll look at that. And then finally, we'll distinguish between civil and criminal law. For the most part, in the business area, we'll be looking at civil law rather than criminal penalties in criminal law. But we will touch on that. But it's important that we understand the difference between those 2 systems. Okay, so where does law come from? And I hope this looks a little familiar because we did touch on this last time. So it comes from the Constitution. That's the law of the land, the supreme law. It comes from the statutes, and these are the laws that are passed by the legislature, either by Congress or a state legislature. And though we talk about them passing laws, we're specifically talking about statutes. Okay? We'll talk about the cases. These come from the judiciary, and this is seen to be interpreting the law, but again, to my mind, it's actually making law. If you can declare something unconstitutional and say it is not a law, that's making or breaking a law. But in any case, we'll talk about that. And you can see it indicates that there are published or reported cases. So again, we touched on this briefly. The cases that come out that we look at and that we consider in the law are cases that are published. So these are the appellate cases, and we'll talk about why that is. Those cases give us the background. They tell us what the law is, so they give us a full story, as opposed to a judgment that you might get from a civil case. So if you take your case to trial, anywhere from small claims up through one of the trial courts, what do you end up with at the end? You end up with a piece of paper. So you end up with a judgment, and it indicates that you won or lost, but it doesn't tell the story. So someone else reading that wouldn't really have any idea what happened in the case unless they happen to have watched it or heard about it in another sense. So we'll talk about the kind of cases that we consider in case law. And then we'll look at the common law principles. And again, we talked briefly about common law. It is our tradition. And it's also considered in many regards the unwritten law. So it's law that developed over a long period of time. Much of it has now been incorporated into statutes or in rules and regulations and discussed in the cases. But there are still some principles that are out there that are sort of traditional that we feel are part of a law but are not yet written down. Okay, so when we talk about the supreme law of the land, what are we talking about? Well, it all goes back to the Constitution. So the Constitution will set out the basic structure of our government. It does divide it into 3 branches. It does indicate what those branches are to handle, what their authority is, that sort of thing. So everything really goes back to the Constitution. There are discussions about whether it's a living document or whether it should be strictly construed, that sort of thing, and we'll get into that as we go along. But again, it does set up the basic structure of the government, and an important part of it is the Bill of Rights. So these are the first 10 amendments, and these are the rights we think of when we think of constitutional law. So we think of the First Amendment, protecting speech, religion, etc. Everybody's aware that you can plead the Fifth Amendment, which means that you don't have to incriminate yourself. And there are various other amendments that we talk about in daily life, but there's a number of them that you wouldn't know. So a fair number of people, unless you've been involved in criminal law, wouldn't know about search and seizure, which amendment that is. If you're involved in hunting or use of firearms, then you've heard of Second Amendment. But a lot of the amendments we don't typically think of, but they are very basic, important protections, and the Constitution wouldn't have passed until those were added. Okay, we're going to look at statutes a little more deeper, and I think we'll take a field trip to take a look at what the legislature does. But again, statutes are passed by the Congress or by the state legislature. An important thing to remember is that we do have more than one system of government. So we have what we call federalism that we'll get into in a minute, which means that there are, in effect, 52 different legal structures in this country. So there's one for every state. There's one for the District of Columbia. There are also some for our other territories and possessions, and then there's a federal system. So in each state we have at least 2 full systems, and we'll talk about what that looks like. But we do end up having separate laws that apply to us in the state, federal and state law. Okay, now they're enforced by the executive branch, and we'll talk about that. We think of the police and other agencies that enforce, and we know that they are interpreted by our judiciary. Okay, and another major area of the law are the rules and regulations, and this is a very complex area. We will talk about that a little bit down the road. This whole area is mostly part of the executive, and these are departments and agencies. There are other types of departments and agencies that may be legislative, but the vast majority of these departments and agencies are executive. And federally, there are hundreds of them, so they're not all called department and agency. We obviously have Department of Defense, Department of Education, but we also have Environmental Protection Agency. We have Atomic Energy Commission, so there may be different names for these departments and agencies, and they produce an awful lot of law. Okay, so we typically think of law coming from the legislature, but the legislature has delegated a function in many, many areas to various departments and agencies, and so there are rules and regulations coming out all the time. Now, even though some of these agencies may be rather small, once they pass rules and regulations, once they are approved, they have the same force as law. So they're just as effective as a statute. And as I said, there's many, many of them. And particularly in business, we need to keep track of the ones that are going to affect our business. Okay, in cases, we keep emphasizing cases. So if we weren't in a common law jurisdiction, the court interpretation and the case part of our discussion would be pretty de minimis. It would be manini. We wouldn't spend much time with it. But in the common law tradition, cases are very, very important. So again, these are appellate cases. So we have books going back centuries that will explain cases. And again, these are cases that have been appealed. So we got old yellow books that will take us back into the 1700s, 1800s in Britain, even earlier. And these are where judges have recorded their decisions in appellate cases. So again, we are talking about cases that have been appealed. So after you go through your trial and you get your judgment, if you're not happy with the result, then you can appeal. So you appeal to a higher court. And that court has the possibility of overruling the lower decision, the lower judgment, and indicating that that is not a proper application of the law. And so you would appeal to a higher court. Now, when you get to a higher court, you are not really having the sort of trial that we see on TV. So you're not having witnesses, you're not having evidence. That all happened down in your trial court. So when it gets to the appellate level, what happens is everything is done in writing. So we would write what we think went wrong. We would explain what the situation is. We'd explain what the court did. And it would indicate what we thought the court did right or wrong that affected the decision. So we are asking the higher court to reverse, to change, or in some way modify the decision that came from the trial court. And to do that, we need to explain to the court exactly what happened and what the mistakes are. All of this is done in writing, so we would submit briefs, in other words, memorandums, to the higher court, tell them what we think the law is, again, tell them the mistakes we think were made, and then the higher court would review both sides and see what they think, whether the court made an appropriate judgment below or not. And then they will explain this. So in our appellate book, we will have a full story of what went on. So it will tell us what the facts were below. And we can see, are those facts similar to a case that we may have an interest in? It will tell us what the court did below, the procedures, whether the court properly instructed the jury, whether the court made a bad decision of law, made bad rulings on evidence, etc. Afterwards, the court will indicate what law they think applies. And then they'll apply the law to the facts, and we'll have a holding, we'll have a ruling as to whether the court below made the right decision. Okay. Now, obviously, that's of interest to us if this is our case, but it is also of interest to us if we have a case like that. So if we want to know how a law is going to be applied, how a court might rule in a particular situation, then we can go and see how they've ruled in the past. Okay, and we'll talk about that in a minute. Generally, the court's going to follow the rules as they happened in the past. So this will allow us to predict what will happen. It will allow us to make decisions and plan, because we'll have an idea of what the court would do in a particular situation. Okay, so again, we've talked about common law, and I think we indicated that number of different ideas about exactly where the term common law came from, and I've read a number of things, and they are very positive that common law came from this particular use of the word. But as you can see on the slide, there's a number of possibilities where it could have come from. So common to all men and places, that kind of makes kind of common sense, shall we say. Common to the king's land, again, this common law arose in Britain, and so the king had various courts and various powers, and to the areas that the king were responsible for were covered by this. Okay, common kinds of disputes. Okay, there were religious courts, various different kinds of courts in England. They handled different types of things. There were courts, separate courts for land, separate courts for, as I said, religious matters, criminal matters, etc. And then finally, it might mean that it applies to the common man. So there was a nobility, and often the rules applied to nobility were different than those that applied to the common people, to the peasants, serfs, whatever. So might apply there. But again, when we think of common law, we are thinking about law that came from England. We're thinking about law that's based on decisions, traditions that end up being followed by the courts. And so we think of this kind of a long tradition, originally oral, but then we started writing down the cases, putting them in the case books, and we think of that as common law. Again, as I indicated, many times common law ends up in our statutes. We pass a statute that embodies or confirms common law, but we still have some principles that we think of as being common law that aren't really embodied fully in the statutes. Okay, some other features are what we call unified courts. And what unified courts mean, now we have, although we have two different side-by-side systems, federal and state, the courts within the court systems are unified. So we don't have a separate ecclesiastical or religious court. We don't have a court that deals only with agencies but doesn't deal with other matters. So we now have a unified court system. And of course, at the top, we have the U.S. Supreme Court. So the U.S. Supreme Court's word on things, constitutional matters, this covers everyone. There's no appeal from there. So all of the courts do follow that. Again, if we look at the civil law tradition, many of those countries still have courts that handle administrative matters. There's no court on top of that can rule on all the different matters from all the different types of courts. So that's what we mean by a unified court system. Okay, now stare decisis. Okay, that little lawyer was supposed to help us with the foreign words, and not here. I'll try and rustle them up if we have any other Latin or specifically legal words. But stare decisis simply means that we have to follow what went before. So when we talk about precedents, preceding cases, stare decisis means that we will follow what went before. And that's one of the general principles in the common law, and that's why we report cases so that judges can see what other judges have decided and they can follow that. And when we talk more specifically the next sessions about courts, we'll see the court will have to follow what the highest court says. So the Supreme Court has the final word, and any lower court, any trial court, will need to follow what the Supreme Court says. Now, do you have to follow what another judge says that's on the same level? No, not necessarily. You can have a disagreement between two judges about exactly how something applies. And of course, if we have two different judges deciding something different, that's the kind of case we would expect would be appealed up so that we do get a final decision as to what the law means. Okay, but you need to follow the highest court, not necessarily your fellow judges. Okay. Now, another thing that's interesting about the common law system is we use civil juries. So we have juries that can decide a contract matter, an injury claim, and not just in front of a judge. And that's fairly unique to the common law system. So civil law countries, code countries, and other areas sometimes will use a jury in a criminal case, but using a jury in a civil case is pretty much unique to our common law system. So it's interesting when people talk about, well, the United States has a lot of jury trials, way more than you would think, and it's kind of how to lie with statistics. So someone might say, well, the United States only has X% of the population, and they have 3 or 4 many times that in jury trials. And that sounds, wow, we must be a very litigious society. We must be suing each other all the time. Well, what they don't really tell you is, yeah, we have most of the jury trials because no place else uses civil jury trials. In essence, that's saying, well, the rabbinical or the Jewish religious trials, 90% of those happen in Israel. Well, no kidding. You know, if no place else uses them, it's not really telling us what number of suits are. Because if we're not counting the suits, civil suits that involve only judges, we're just counting juries, it's a meaningless statistic. And finally, the adversarial system. What is that all about? Well, originally in England, there were various ways of resolving disputes, and fortunately we don't use them now. They had trial by combat. So You would fight and see who won. That would indicate whether or not the powers above felt that you were righteous and should win. There were other types of procedures, and they've kind of been embodied a little bit in what we call the adversarial system. So what exactly does that mean? The idea is that two different sides will both make their best case, and somehow that will put the information in front of the person making the decisions, and that will be the best way of getting the best information for either side. And then the fact finder, the person making the decision, will be able to see best shot which way they think it should go. Okay. Now, again, here's some of the ideas that came out of common law that weren't necessarily embodied originally in any enactments in any statutes or were written down. So one would be the trial by jury that we've talked about. The idea that someone is innocent until proven guilty came out of the common law. So now, most of these now are embodied in our statutes, so they've been passed and they're now part of the written law, but they started out as the unwritten law. So other types of sayings or thoughts that influence the law that aren't necessarily written in that fashion would be things like a man's home is his castle. In other words, our ideas about privacy, our ideas about private property, all of these developed out of the common law. And again, eventually they ended up in a lot of our statutes, but some of our ideas still are influenced by the common law and are not worded in that exact way in our statutes. Okay, now again, we talked about the supremacy of the law, and we know that the Supreme Court is ultimately the final decider, the arbiter of what the law means and how it should be applied. But the idea of supremacy of the law is even broader than that. And this was, again, at the time, if you go back historically, this was a very original sort of idea, because previously in Europe and most of the rest of the world, the rulers were supreme. So the rulers had been given their power directly from above, directly from God, and so they could do no wrong. And so when they made decisions, they did not need to have any type of representative government. They needed no necessary input from anyone else because they could do no wrong. And over time, this developed in England, where the nobility and finally even the common people were determined to have rights. So we hear the phrase that we are a nation of laws, not men. And what does that mean? Again, that means that the law should apply to everyone. So it doesn't apply one way for rich and one way for poor. Now, we can talk about practical effect of wealth, etc., but under our law, again, it is meant to be objective and apply equally to various people. And again, this is, remember, we had our justice with the blindfold, and that's again what we're looking at, is we're looking for impartial decision making. Doesn't matter whether a person in front of you is nobility, or, since we don't have nobles in the U.S., maybe celebrity or someone else. Should be treated the same. And again, historically, Magna Carta was several centuries ago, and this was the first time when the king relinquished some power, and at that time did not relinquish power to the common people exactly, relinquished power to the nobility. But again, that doesn't sound like much, but at the time that was quite unique in giving up any power whatsoever. And it took many years, of course, for the power to trickle down and representative government to be more representative or democratic. Obviously, at the time, the nobility was essentially men, and we've seen in our own history that it took a while for everyone's rights to be equated. But again, this was a first major step, and this idea that the law is above individuals, including the leaders, is something that was quite original at the time. Okay, again, stare decisis, and even without little lawyer, we can see this just means following the decided cases. If the cases are not exactly in point, then that's where we get the interpretation. So we will be looking to see if our case is the same as a case that's already been decided, our situation. And if it is, then we would expect the court would follow what went before. If it's not, then we would be arguing whether or not this case should apply. Is it close enough that it should apply to our case? Now, oftentimes, and this is particularly true in a smaller state like Hawaii, there may not be a prior decision exactly about this particular matter. And in that case, we might have to look at cases that are close. We might have to look at cases from other places. We might have to do various things to see what the court might do. And we'll talk about that more when we're talking about interpreting cases. But it's entirely possible that there will be one case in our state, in our jurisdiction, that covers a certain matter, and both sides will need to talk about that case. And so one side will be saying, we should follow that case. We should have stare decisis. That's a precedent. That's something we need to follow in our situation. And the other side may say, no, that case is different. Some similarities, but the differences are really critical differences. We shouldn't follow that case. So there is a lot of interpretation going on here. And as we talked about, there are times when the court will not follow prior cases. So there are instances where the court will overrule what went before. And there are various reasons for that. Either deciding that the law wasn't well decided originally, deciding that things have changed, we now have more information, society has gone a different direction, that sort of thing. So certainly we can overrule cases. But in general, we need a compelling reason. We're going to be following what went before unless there's a good reason to change. Okay, again, juries worldwide are unusual. And the jury system actually, particularly in the civil area, tends to kind of update the law over time because the juries have different sense of what morality is, what proper conduct is. And so slowly over time, having the jury decide things actually is kind of a representative way of interpreting the law. So we not only have legal experts interpreting, which is more nearly the case in the civil law traditions in other countries, where you have the legal experts and the judges interpreting the law, but in some sense we have the juries interpreting the law. Now, we'll talk about how the jury system works, but we typically think the jury is only determining the facts, and the judge tells them what the law is. But if you think about it as a practical matter, having the juries involved in making these decisions clearly is going to inject kind of a community sense into what's going on. And we talk about a jury of our peers, so we do attempt to get a jury that is representative of the population. And again, we'll talk a little bit more about that when we get directly into the courts. Okay, now, do want to touch back again on the adversarial system. We tend to think of trial as being a little bit of a battle, and again, that came from our historical background, but it is the idea that the person that believes in a case, that is affected by a case, is going to be a good champion of that case and be able to explain it and will pull out all of the stops, so to speak, so that they can present the best foot forward on that case. And the other side will do the same thing that has an opposing view. The idea is that throwing these positions into the mix, then somehow the best arguments for either side will be there, and then the fact finder can kind of sift through those and look and see, okay, I've heard the best shot from both sides. Which way would I go on this? Okay. Now, other systems, civil law tradition does not do that. Generally, the judge will have much more control over things. The trials will be, in other countries, are frequently more fact-finding. There's not kind of an adversarial thing. There's not a face-to-face. There's not these oral arguments where people are arguing, cross-examining, that sort of thing in the same way. So the trials may look quite a bit different in other systems. But in our system, we believe that helps the truth emerge. Now, we will be talking about alternative dispute resolution. In other words, cases that don't seem to work that well in the adversarial system. And if you think about that, you can kind of think of examples. If you have a family matter, husband and wife get divorced, they are going to continue to meet to deal with their children. Having a battle about that obviously is not the best way of handling it. So that's where we look at things like mediation, where we help people talk to each other without kind of the adversarial approach. Similarly, if you have labor disputes, employers and employees are going to, for the most part, continue to work together. So again, suing each other is not conducive to having a good working relationship. And that's why arbitration started very early in labor. So we had labor management, union management, arbitration to have a kind of kinder way of doing that. So you can think about cases where if there's a continuing relationship, that we might want to look at something other than the court system to handle those better. And that's typically where we have ADR, alternative dispute resolution, is in situations where there's going to be a continuing relationship and we would like to have it a friendlier way of dealing with things. Okay, so I want to, again, underline some of the uniquely American features. And again, this, although we're a common law country, we've added some things that we won't find in Britain. And again, one of those is the Supreme Court. So Britain does not have anything resembling the Supreme Court that covers any and all matters. They don't have the ability to declare things unconstitutional. So that's fairly unique. Now, again, a lot of this is historical. We won't go into the dim past except a little bit just to kind of point things out. But this came from our distrust when the country was founded of having too much power in the executive. So they'd already messed with King George, didn't like having that sort of taxation without representation, etc. So we have a very distinct and clear separation of the powers. And we also talk about balance of power. So we have the Senate is able to confirm judges, the judges are able to do this, the executive has to follow that. So we have that system of checks and balances so that we don't get, we're trying to avoid too much power in any particular area. Okay. Now we'll also see that that's part of our federalism system as well. In other words, balancing between what the states do and what the federal government do. And that's obviously a continuing debate. Okay. Again, we've talked about separate court system in each state, and we'll look at how do we know where a case would go. So how do we know whether a case is going to be a federal case or a state case? And again, we'll touch a little more when we actually talk about jurisdiction, because jurisdiction means the power or authority of a court. And so we'll see whether or not this is the federal jurisdiction or whether or not we look at state jurisdiction. Federal jurisdiction is more exclusive. So typically we'll see if is this a federal case. If it's not, then we will be looking at state cases. Okay, again, the judicial review. This is the power of the courts to interpret whether or not a statute is constitutional. And people from other countries are kind of amazed when they see that the legislature can pass a statute, representative government, all the people have agreed to it, passes, let's say, unanimously or almost unanimously by the legislature, both houses, becomes law. And then the court, Supreme Court, indicates that it does not pass constitutional muster. In other words, it is contrary to the Constitution. And it can indicate that the law will not be effective. So, again, that's very unique to our system. There are all the time people talking about courts being activists or not activists, how strictly we construe the Constitution, what the Constitution actually means. Are we bound by the view they had of things in the 1700s, or is it a growing document? So there's all sorts of debates about this. But the long and the short of it is, is our Supreme Court can declare a statute passed by Congress to be unconstitutional, and our state Supreme Court can do the same for things passed by the Hawaii legislature. Okay. So when we look at federal law, what are we looking at? Well, we're looking at things that would cover national interests, so things that we think only the larger entity, only the nation could handle. And this might be defense, this might be international relations, that sort of thing. So these are areas that we think we need to be all together on this. Okay, the old, if we don't hang together, we will hang separately. So things that require the entire body to do. Other things would be the interactions between states. So the states may not trust going to the court of another state if their dispute is with the state. So this is historical. This is how we ended up with federalism. We had, for example, border disputes between Virginia and Maryland. So obviously Maryland would not want to have their border dispute with Virginia handled by a Virginia court and vice versa. So part of our jurisdiction for federal courts is going to be handling matters between different states or between different countries. The idea being that you don't want to go to the home court, you don't want to go to a state if you're suing that state or somebody from that state. Okay. Again, we look at some very basic rights. So if they're constitutional rights, then they're going to apply across the entire country. So the constitutional rights are going to set a floor. So the federal law there is going to be the minimum that every state has to meet. Now, can the state provide more rights to its people? Sure. You can think about things like minimum wage, that sort of thing. So the federal law will provide a minimum that you have to meet, but you can do more in various areas. This is particularly true in the business area, but also even in some of the basic rights. We have more rights in Hawaii in certain areas than you would in the federal Constitution. Okay. Okay, now state law is meant to be, obviously, more local. So if it's not something that's going to be handled by federal law, then we're going to handle it locally. We're going to handle it in the state. And so state laws can vary considerably. When we talk a little bit about civil and criminal, there's an easy example there. Some states have the death penalty for certain crimes. Other states do not. So they're going to differ in that regard. Many states are going to have traditions that have come up, again, historically from where they are. For example, Louisiana was part of the Louisiana Purchase and is obviously very French. You've probably had New Orleans cuisine, so you're familiar with there's a very strong French Creole aspect to that. And their law also differs considerably. They still have a lot of the civil code tradition. So be fortunate we're not studying Louisiana law, because we'd need the little law you're translating. We'd need a French little lawyer, because they still use many, many French terms and a lot more Latin terms with their civil code tradition. Okay. Now, Louisiana has joined us in the criminal law. They do obviously have to follow federal laws and federal constitutional limits, but their internal law, their state law, is quite different. Okay. So I may do a trick question at some point and indicate if would Hawaii follow Louisiana law because we're both maritime jurisdictions. We both have a lot to do with the ocean. And the answer would be not very likely any state laws because, again, they don't have a strong common law tradition in Louisiana. What are some other examples? Well, a lot of the southwestern states have a strong Spanish influence. So some of the ideas about community property owned by married couples comes from the Spanish tradition. So we may have those aspects individually in those state laws. And in Hawaii, we have a number of areas where we have taken on some of our background, our Hawaii way of dealing with anything. So we have consideration for the Kuleanas, consideration for the ocean, consideration for how access to beaches. So there's a lot of things in that way that we've incorporated from Hawaii's background. And we actually now in the court systems we have dispute resolution that is based on indigenous and Hawaiian background. So we have ho'oponopono being used in our courts. We also have other types of kind of group involvement in decision making, which may differ from other states. And again, that comes out of our own island traditions and backgrounds. Okay, I'd like to cover now the civil and criminal. Most of what we deal with in business law is going to be the civil side. But let's take a quick zip through the civil and criminal, because there are some distinctions, all the way from who the person that's injured is, in other words, a victim of a crime or somebody that has been injured civilly. The source of law is a little different. Okay. The name of what violating the law is differs. They handle, obviously, different subject matters. There's differences in how you start a criminal and civil case, different in what you have to prove. We hinted at this when we talked about the difference between O.J. Simpson's civil and criminal trials, different defenses. Constitution actually protects criminal defendants more than it protects people in civil disputes, and there are different penalties, different results at the end. So we'll take a quick look at these and get an idea of what those distinctions are. Again, the majority of the laws that affect us as in business are going to be on the civil side. Okay, so with respect to the injured parties, in a civil case, the injured party is an individual or an entity or a group. So if someone runs into my car and injures me or injures my property, then I would bring that suit against whoever did it. So I would be looking to have them found liable, in other words, would pay damages, would fix what they had done to me. And as the person bringing the suit, I would be the plaintiff. The person that I sue, the person I bring the lawsuit against, would be the defendant. And we will, again, talk considerably about how court cases are in our next session. On the criminal side, however, the injury is seen to be against society. So in doing this act, you have caused an injury to everybody. Okay. Now, of course, you may have caused a specific injury to a person. For example, if you ran into me and you were a drunk driver, then I may be able to sue you for what you did to me, and the state may bring an action against you as well. So they may bring an action because you have driven while intoxicated, and that's against the law. That's an offense against society. So my case would be injured person versus drunk driver, and the criminal case would be state of Hawaii versus drunk driver, because driving drunk has been an offense against all of society. So the cases that we see in the criminal side are going to be state of Hawaii versus criminal, or United States versus criminal. And again, other states may call themselves Commonwealth. California, I believe, calls themselves people, so it would be people versus O.J. Simpson. But again, it's the government that has been injured and the government bringing the suit. So that's a major difference. And as we talked about, many of these crimes also, if someone's injured, will lead to a civil suit. So we can have a civil suit and a criminal suit arising out of the same interaction. Okay, the source of law, obviously, it comes from the same sorts of places. Generally, it comes from the statutes. There are constitutional protections, etc. But the difference is the criminal law cannot be common law. So to be subject to criminal prosecution, to have committed a crime, it needs to be statutory. So we need to be able to know exactly what it's violated, not that we violated some general tradition or moray or something. We need to know exactly what it is that we violated. So where we may have some common law concepts that end up in the civil side, for example, in the automobile accident, we have some ideas about what's negligent, how a reasonable person would act, and those may be common law. Some of them will be in the statutes, there may be traffic laws, etc., but some of them will be, we know that this is what the reasonable person would do, and we can base it on that. But if we're accusing someone of a crime, it needs to be statutory. Okay, again, different subjects that we handle. So on the criminal side, we're going to be looking at injuring people. On the civil side, we're going to be looking at injuries to people or property, and we call those torts. We're going to be looking at how to handle the agreements with other people. We call those contracts. We'll be looking at property, probate, family. A lot of the personal relationships are going to be handled on the civil side. Okay. On the other hand, on the criminal side, we're going to be talking about crimes against the person, so murder, kidnapping, assault, etc. And again, crimes against the person could be civil and criminal. So do recall that we sometimes will have either the same name or a different name, but for the same action. Okay. Be crimes against property, and there can be miscellaneous things. We talk about victimless crimes, and those would be crimes where it's not clear that you've injured a particular person, but perhaps you're injuring society, or in general we feel that it's a bad result. So that could be morality. Some people think that minor drug use is in that area. There's debates about some of these, of course. Okay, the way we start a case, civil side, we simply bring a lawsuit. So we would decide that we've been injured, someone has damaged us, someone has failed to do what they said they would do in a contract, and then we would bring a complaint. Sometimes it would be a petition. We use the word petition in family court, sometimes in probate court, but many of our complaints would be for an auto accident, for example, would be a complaint. Now, on the criminal side, again, it's the state bringing the action. So that would have to be a determination by the state, by the appropriate state officials, that a crime has been committed. So we would expect the prosecutor to look at this, and we would have a grand jury perhaps. So this results in an indictment or an information that comes from a government official that decides, yes, this person has violated a statute, and we want to prosecute them for that. Okay, we touched briefly on this standard of proof earlier. This is the distinction that many feel was the difference in the result between the Simpson case, the criminal side, and the civil side. So in a minute we'll talk about the penalties, the sanctions, the results that come at the end of a criminal case, and these are more serious. So they involve incarceration, being put in jail, and as we indicated, sometimes they may even involve the death penalty. So since these are more serious personal affronts and or death, the repercussions are more serious, we tend to provide more protections on the criminal side, and we require a higher standard of proof. So in order to prove someone guilty of a crime, we say that you have to prove that beyond a reasonable doubt. And that means you can't really think of any other explanation. That's pretty much you feel that the person has done that they are in fact guilty. Okay. On the civil side, it's a considerably lower standard. So we talk about a preponderance of the evidence. And what in the world is a preponderance? Well, we're really talking about more likely than not. So if we were doing percentages, and we're not really, we would say anything over 50%, that's going to be a preponderance. On the other hand, beyond a reasonable doubt, that's right up there. Okay, that's closing in on 100%. Okay, again, we don't use percentages, but just to give you an idea of the range. Some civil cases, for example, fraud, have something little bit in between called clear and convincing. Okay, but for the most part, we're looking at preponderance of the evidence, and we're looking at beyond a reasonable doubt. Okay, there are different defenses. In some, for example, an assault as a criminal act, you could say self-defense, and actually assault as a civil claim, you might have self-defense as well. So again, there may be some similarity there, but there are a number of other types of defenses, particularly on the criminal side, that have to do with how the evidence was collected, and again, are providing protections for people charged with a crime. Again, partly because of the penalties and partly because the entire weight of the state is coming after this individual. So we'll look at things like alibi, illegally obtained evidence, being tried twice for the same crime, which is double jeopardy, that sort of thing. Okay, as hinted earlier, there are more constitutional protections on the criminal side. We have the Fifth Amendment against self-incrimination you can use in both types of cases, but a number of additional protections occur in the Bill of Rights and elsewhere with respect to criminal side. So right to a speedy trial. A criminal trial cannot drag on like some of the civil cases might. You have a right to counsel. In other words, you remember the Miranda rights that say if you do not have a lawyer, we'll appoint one. So there's those types of protections. You may have heard about cruel and unusual punishment. Again, that's criminal side. And again, illegal search and seizure, that sort of thing. So how evidence was obtained. Okay, at the end of the case, we talked about different results. In a civil case, usually what happens is your damages, your result, if you win, is going to be money. So we'll talk more about whether or not money can compensate you for losing a body part or being injured, losing time, losing a loved one. But in our system, money is kind of the currency, so to speak, of how we try and make somebody back how they were, how we try and fix or compensate what happens to them. Now, a civil case also can tell somebody to do or not do something. That's called injunctive relief, temporary restraining order, etc. We'll talk about that. You can be, if you get a money judgment, they can help you collect it, and we'll talk about that. And then finally, you can appeal. At the end of a criminal case, you'll probably be sentenced. So if you're convicted, if you're found guilty, they'll check on what your situation is. You can be fined, in other words, have to pay money to the government, or you can be charged with restitution, which means you have to pay money to the person you injured. If you may be sent to jail, again, might be death penalty, not in Hawaii, but federally and in several states, and then also possibility of appeal. Okay, that was a lot of material. So we did cover sources of the law, where it comes from. We covered some uniquely American features. We covered differences between civil and criminal. So again, we're getting into a little more detail here. And let's look at what we're going to cover next time. Next time, we're going to dig real deep into the court structure. So we're going to talk about how cases happen. We're going to talk about how they're started. We got, again, a little bit of a hint of that today, but we're going to get into the mechanics of how to file a suit, and after cases are decided and after they're appealed, how to use those to assist us in planning both our business and our personal affairs, so to speak, to stay out of trouble. Okay. So, this has been Carol. Aloha from Business Law 200. See you next time. Be sure to look at the Laulima site if you're taking the course for credit. Aloha.